Hello, good evening. Can we all hear me? Good evening.
Yes, sir.
Good
Good
evening,
evening.
sir.
All right. Thank you all for joining in and welcome to class. And welcome to class. We are welcome once again back to today's session. Um, so I just want you to give me a moment. We'll be starting right about now. So please just give me 1 minute. I'm coming. I will get back to you guys right now. All right. Good evening, everyone. Thank you all for joining in for today's session. Welcome to our rescheduled session from Sunday. Right. In today's class, we'll be discussing what we're supposed to do in the last class. And I just want to say thank you to everyone who has been able to make it to class today. We really, really do appreciate. So to not be wasting time in today's class, as we want to just go ahead and make sure that whatever we lost on yet last week, we get to catch up. Right. So please, for the mentees that are in class, please, you can reach out to members of your subgroup to let them know that this particular session has started, right? So that we have more people joining for the session. I will still send a reminder into your group so that we have more people joining, right? But not to waste any time, I'll just be handing over to Mr. Ebenezer. Thank you so much, sir, for joining. And we're happy to have you in the session, sir.
Thank you, Mr. Dennis. I believe your week has been stress-free, so to speak. Sorry, just a few minutes. Okay. I think we're having better reception here. Maybe I'll be having Sunday webinars from my office so that we won't be having network challenge. Okay, so how many of us are here? I can see 10 people. If you remove Dennis, that'll be 9. Okay, one person is using 2 devices. Benis is having 2 devices. Okay, quickly, I need to let's rush through this. Patients' rights and legal protection. Okay, I was commending the group that presented, both parties that presented last week. And I was saying that I was impressed with their work, with the thorough nature, the extent, the depth of the research. So, and I was saying that for the patient's rights, I was saying that our starting point should be from definition, because you just have to start to know what you are dealing with. Firstly, who is a patient? Before we talk about the rights of a patient, I asked all of you to join my webinar on last week, Thursday and Friday. Unfortunately, only few persons joined. So that will make me, I wanted you people to pick a background, because that webinar, the scope of the webinar is beyond the scope of this class. But that having been said, let's look at a few things. Number one is that if we talk about a patient is a person who receives a medical care or treatment from a healthcare professional. We already know that. That treatment could be for different reasons, or the kind of treatment, it could be for different reasons. One, it could be to prevent an ailment. It could be because of an injury. It could be because of a chronic condition. It could be because of mental health. It could be because of surgical procedure. So people go to hospital either for curative or for preventive purposes. The patient can also be defined as anyone who is under medical care. in a healthcare facility, whether be it a hospital, be it in a clinic, be it at home or virtually, because we now have a virtual medical practices, what we call telemedicine. In fact, there's a video I'm supposed to have posted on your platform, but I delayed to wait for when we are going to have that, when we are going to treat that topic. The video, India just performed the first in the world robotic surgery, intercity robotic surgery. The doctor performing the surgery was in a different cities, like somebody's in Abuja and you are performing, the doctor performing the surgery is in Abuja while the patient is in Lagos. And the doctor does a remote surgery from Abuja using, of course, electronic device and robots just moving, and in real time, that surgery was performed. So I am going to share the video in this on the platform so that you people understand what I'm talking about. But the point I'm making is this, that whether you are in the hospital receiving care, or you are at home receiving care, or they are treating you from or remotely, they are treating you via virtual platform, you all fall into patients. Now, Section 64 of the National Health Act, which is the definition section, uses the word user to define patients. So if you are looking through the National Health Act, in place of patient, you'll be seeing user, any user, for a user, user. So when National Health Act talks about user, it's referring to a patient. But let's look at who the National Health Act says a user is. It says a user means a person, the person receiving treatment in a health establishment. In fact, there's no need wasting time here. We already know who a user is. But I'm referring to National Health Act because it has broadened the scope of the discussion. Before now, we can limit patients to the person receiving care, but the way National Health Act has defined the patient as a user, the B part of that definition now says that the user includes the person's parent, that the parent of the patient or the guardian of the patient, well, that is where the patient is a minor, or another person authorized by law to take care of the patient. That's the first mentioned person, where the patient is incapable of making decision. Then they now went further to say that user also includes the patient's spouse. So where an adult person is receiving care, his or her spouse is also a user, meaning that that user can now bring an action. That's the point I want to bring out of this. That user can now bring an action on behalf of the primary patient who is receiving care. Then, in the absence of a spouse, where this adult person doesn't have a spouse, user includes the person's parent, grandparent, or adult child, or brother or sister. Now, you have seen that the term user, who we call patient, has been broadened by the National Health Act. So let's look at the definition of a patient's rights. I did say in my webinar that patient's rights so far defies definition so far. So what that means is when you Google patient's rights or the meaning of patient's rights, you are most likely to see description rather than definition. You are most likely to see a listing. Patient's rights includes, patient's right refers to rights to consent, rights to informed consent rather, rights to privacy, rights to information, all those rights. But there is no holistic or all-encompassing definition that captures what patient's rights represents. So a few definitions is patients' rights are the ethical and legal principles that protect individuals receiving health care, ensuring they are treated with respect, provided with necessary information, and they're empowered to make informed decisions about their care. You see, ensuring they are treated with respect, one. Two, they are provided with necessary information, two, and empowered with informed decision about their care. So they just mentioned three rights here: dignified care, right to information, and informed consent. These rights are fundamental to the patient-centered approach to healthcare and promotes a safe and supportive environment. Fine. But you get the point I was making, that all attempts I've seen to define patients' rights comes up with mentioning what those rights actually are. So that drove me to, in 2019, no, 2018, come up with this definition. The patient's rights are those rights that guarantee professional, quality, transparent, and safe healthcare delivery to a patient, as well as respect for the dignity of the person of the patient by healthcare professionals while providing healthcare service to the patient. So you now see that from this definition, there are 5 major components of patient's rights, or the patient's rights must guarantee 5 major things. One is professionalism of care. 2 is quality of care. 3 is transparency of care. 4 is safety of care. And 5 is respect for the dignity of the person of the patient. So if any of these qualities or is missing while receiving care, you are most likely, patient is, sorry, they have taken my light, so let me just open the. So if any of these components is missing, that patient is likely, most likely to suffer violation of rights or negligence. So now let's look at the sources of patients' rights. Quickly, we have different sources, basically international conventions and treaties are there. Then we have local legislations. Well, under international conventions and treaty, you have like the Universal Declaration of Human Rights is there. You have a Geneva Declaration, which is the Hippocratic Oath, which is the oath every doctor takes on induction, during their induction. So that's Hippocratic Oath. Another is a International Covenant on Economic and Social Rights. We have the Helsinki Declaration. The Helsinki Declaration condemned the use of human experimentation. If you read about the Nazi inquisitions, so to speak, where they were just trying all manner of things to see. They can carry a human being and put him in a boiling oil to see what his reaction will look like. They can carry somebody and put inside ice block to see what his reaction will look like. Conducting different experiments using human beings. So the Helsinki Declaration was the first set of documents that brought about research ethics and raised the issue of informed consent, that human beings are not guinea pigs, that for you to use humans for experiments or medical experiments, there have to be ethical guidelines that should be followed. And more importantly, the person's consent has to be sought and obtained before undergoing such experiments. Then we have the Declaration of Tokyo. We also have the Lisbon Declaration. Lisbon Declaration is the first attempt globally to bring patients' rights as a single document. In fact, the first effort to codify patients' rights, to have them written down. Before now, the principle of paternalism held sway, where the doctor makes all the decisions for and on behalf and in the best interest of the patient. But now we have patient's autonomy being the position. So prior to the Lisbon Declaration, there was nothing written anywhere that we could call patient's rights. All the rights of the patients were as offered to him by the doctor or by the healthcare professional. So with Lisbon Declaration, we begin to talk about patients' rights now being documented. Then we have African Charter, Article 5, Article 6, Article 16, all confers different rights on the patient. Now, note that these are at the international level. Then we come to domestic. We have acts of the National Assembly, starting with the Constitution. The whole of Chapter 4 talks about patients' rights. Not patients' rights per se. They are fundamental human rights. But from there, you can extract some patients' rights. So freedom from torture is there. Freedom of movement, privacy, they are all under Chapter 4. But the most important there is right to life. Because where there is no right to life, you have no other rights, whether as a patient or any other person. So the most cardinal rights of the patients under Chapter 4 of the Constitution is right to life. And how does this right to life come to be? By government making available or putting in place as provided under the different international treaties Nigeria is signatory to, conditions that will make the patient maximize his health and live a good life, a healthy life, providing access to medication where a patient falls ill and does not have access to quality health care. That person's right to life is being denied. Then we also have the National Health Act, which is the principal act now governing healthcare in Nigeria, service delivery. We have compulsory treatment and care for victims of gunshots. We have HIV and AIDS Anti-Discrimination Act. We have the Mental Health Act. We have the National Health Insurance Authority Act, and a plethora of other acts of the National Assembly. I believe by now you should know the difference between acts and law. Acts are the laws made by the National Assembly. Laws are the ones made by the states. State House of Assembly. So after act under domestic legislation, we have acts, we have state laws. Examples are compulsory treatment and care for victims of gunshot laws of Rivers State, persons living with HIV/AIDS law of Lagos State. Then we have codes of the different medical and healthcare professionals. Doctors have their code of ethics, which we call the code of medical ethics. Nurses have theirs. What's their name? Laboratory scientists, physiotherapists, anesthesiologists, pharmacists, radiographers. All these codes have in them different rights of the patients. Then you have subsidiary legislations, regulations, and policy frameworks of relevant government agencies. That is where the Patient's Bill of Rights falls in, the minimum standard guideline for treatment of persons receiving care in COVID facilities in Nigeria. That was produced by the National Human Rights Commission. Then you have the Coronavirus Health Protection Regulation 2021. All these are under regulations. All these are under subsidiary regulations, subsidiary legislations, and policies of governments. Then you have substantive law, constitutional law, the Constitution itself, of course, Chapter 4. Then you have law of contracts. Then you have law of thought. These are places that patients' rights are derived from. Law of thought, we're talking about negligence. So the principle of autonomy is derived from law of thoughts. Then you look at law of contracts. I said that whenever a patient walks into a hospital, a contract is established. And unfortunately, both the doctor and the patients most times do not know that that relationship, doctor-patient relationship, is also a contractual relationship that has legal implication because there are implied terms and express terms. So from here, law of contracts, patients' rights also emanate. Then we have case laws, decisions of courts saying this is what constitutes patients' rights. This is what constitutes patients' rights. This one is not patients' rights. And one of such is the case of Schlendorf against Society of New York Hospitals. Now, in that case, Lord Cardoso held that every human of adult years and sound mind has a right to determine what shall be done to his own body. And a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages. So where a doctor performs surgery without consent, he is liable to assault. Now, this case is the locus classicus on patient's autonomy. It's a 1914 case. Nigeria has also borrowed from this case in the case of Medical and Dental Practitioners Disciplinary Tribunal against Okonkwo. In that case, Dr. Okonkwo refused medical treatment, did not transfuse blood to a patient who has refused expressly to receive blood. In fact, the patient put it in writing, no blood transfusion. So the doctor simply obeyed the wish of the patient. When the patient died, the family of the patient, relatives, they sued the doctor. They took the doctor before the Medical and Dental Council, and the doctor's license was withdrawn for 6 months. And of course, the doctor went on appeal. The Court of Appeal reversed the decision, and the Medical and Dental Disciplinary Tribunal went on appeal further to the Supreme Court. And the Supreme Court held that the doctor was right to respect the religious belief of the woman who says she does not want blood transfusion. So you see now that case law has formed parts of our source of patients' rights. Case law has formed part of the source of our patients' rights. Excuse me. Just give me a moment. Okay, sorry for that break in transmission. Okay, so Okonkwo's case is there as a proof that case law is one of the sources of patients' rights. So let's look at the patients' rights that are now applicable in Nigeria. We have right to life, Section 33 of the Constitution. And the person group one, they did an excellent job. In fact, when I saw Odafe, this case is not popular in the face of everyone. When I saw it, I'm like, okay, this is a good one. So, Section 33 confers right to life or guarantees right to life. And it gives exceptions to right to life. And one of those exceptions is not when a person dies as a result of medical negligence or medical malpractice. That is not an exception under the Constitution. So any death occasioned by medical malpractice or violation of patients' rights is a breach. It's a breach of Section 32 of Section 33 rather of the Constitution. It's a breach of Section 33 of the Constitution. So that I had a call. Let me send a message to the person. Okay, so Article 4 of African Charter also guarantees right to life, and the courts have held that African Charter is applicable in Nigeria because Nigeria is a signatory to that charter. Then we have, trying to rush, rights to information. Now, this right is provided under Section 23 of the National Health Act. There are 5 components of rights to information. Information as to the risk or the nature of the ailment, 1. So you tell the patient what is wrong with him, the nature of the ailment. 2 is the treatment options available, not the treatment option your facility can provide. 3 is the benefits or risks of each treatment option. 4 is the cost implication of each treatment option. 5 is the patient's right to refuse that treatment. You must tell the patient, these are the treatment options available, these are the benefits of each treatment option, these are the risks involved in each treatment option. Then after you have done all that, you now tell the patient that he has a right to refuse the treatment. And all this should be done in a language that the patient can understand. Where the patient does not understand, communication is not, it's about understanding. Where the other party does not understand what you say, you have not communicated. It's like 2 people, one is speaking English and does not understand any other language. The other one speaks French and does not understand any other language, and both of them meet. There will be no communication, even though both of them are speaking. So this one will speak in French, the other one will speak in English. The Englishman does not understand the Frenchman does not understand English. That is what happens between a doctor and a patient, where the doctor is addressing the patient in with his medical terminologies. We have rights to consent, informed consent. Now, informed consent is a product or byproduct of rights to information when that information is properly given. So the patient evaluates the information and makes a choice and decides which of these treatment options am I going to take. So that is rights to informed consent. Now you have to, after you have given the patient information, the patient weighs his pocket, weighs the risk he's able to absorb. then weighs everything and makes a choice, and now authorizes the healthcare professional to proceed with treatment. That authorization is what we call informed consent. That consent has to be freely given. It has to be reversible, meaning the patient can withdraw consent at any time. That consent has to be informed and it has to be emphatic and specific. Now, in the case of Okekaro against Tanko, a young boy of 14 years, his finger was cut off without his consent because he went for treatment, and while he was treating, the doctor saw the need to treat the other finger. Then the doctor didn't even tell the boy in question. The doctor only whispered to his auntie, and the auntie said they should chop off the finger. And they cut it off, and they went to court. And the court held that the boy of 14 years appreciated what will be done to him and was in a position to decide whether he wants to have his finger cut off or not. So the court was wrong, or rather the doctor was wrong in cutting his finger without his consent. Then, of course, right to emergency medical treatment, Section 20 of the National Health Act. Every patient has a right to treatment in emergency. Now, this does not confer on any patient right to free treatment. They are two different things. Our law so far does not give us right to free treatment, but right to treatment in emergency. What are treatments? What are emergency situations? Labor is emergency. A woman in labor is an emergency. Accident is an emergency. Cardiac arrest is emergency. Snake bites is emergency. Dog bite is emergency. Now, that does not mean that the patient will not pay. It means that the life of a patient is more important and should be saved first. So, where a hospital fails to comply with the provisions of Section 20, that hospital will be liable to a fine of 100,000, and the healthcare personnel could go to jail for a term not exceeding 6 months, or they'll pay both fine and serve a jail term. That is for emergency. Then the Compulsory Treatment and Care for Victims of Gunshot Act 2017 also provides for these rights. Section 1 says that hospitals in Nigeria, whether public or private, shall accept or receive for immediate and adequate treatment persons with or without police clearance, any person with gunshot wound. So any person with gunshot wound should be treated with or without police clearance. Now, before now, it was the practice that victims of gunshot will first of all go seek police reports before they come and receive treatment. Just imagine that the person is losing blood and the person is going about seeking police reports before he will receive treatment. The person will just die. Then subsection 2 now says that such treatment could be given to the patient with or without, should be given to the patient with or without initial deposit of funds. Says the person with gunshot wound shall be received by any hospital in Nigeria for immediate and adequate treatment with or without initial deposit of funds. Then the Patient's Bill of Rights also provides for this medical emergency treatments. Then even the Code of Medical Ethics also provides for this. Now note, a doctor is not bound to treat a patient in emergency. That's where the doctor sees the patient on the road. But once a doctor volunteers to treat, that doctor has to exercise reasonable skill and care, degree of skill and care of a medical practitioner of his standing. Then under Section 10(4) of the Federal Road Safety Commission Establishment Act, which establishes the road safety. The road safety officers have a right to prosecute hospitals that reject or refuse accident victims. They have rights to respectful and dignified care, Section 34 of the Constitution, Section 22 of the Compulsory Treatment and Care for Victims of Gunshot Act. You also have it under Section Rule 11D and E of the Code of Medical Ethics. The Patient's Bill of Rights also provides for this. Now, what's important, this rule frees the patient from torture, physical or verbal abuse, or discrimination of any kind. We're talking about a dignified care, respectful and dignified care. So anything that we reduce the estimation of the patient in his own eyes, whether done verbally or through physical abuse or torture, is a violation of these rights. So Section 2, Sub 2B of the Compulsory Treatment and Care for Victims of Gunshot Act 2017 provides us a person with gunshot wound shall not be subjected to inhuman and degrading treatment or torture by any person or authority, including the police. So even the police, they should not torture or manhandle a person with gunshot wound. Then we have the next, right to privacy. This is one right that most hospitals obey. If you go to hospital, you see them providing screen, shield, that curtain-like stuff that has wheel. When they want to treat a patient, they use it to cover the patient so that other persons will not see the naked body of the patient or the site of the wound. So, right to privacy is provided under Section 37, even though that of the Constitution is different from this, but it falls. Then Section 11, Rule 11A, Code of Medical Ethics. Then we have a Patient's Bill of Rights there too. Then right to confidentiality of medical records provided under Section 26(1) and 2 of the National Health Act. Then we look at Rule 9F of the Code of Medical Ethics, which provides that patient-doctor communication should be confidential. Then we look at Rule 8B of Code of Medical Ethics, paragraph 2 of it, places the doctor on absolute confidentiality on all he knows about the patient, even after the patient has died. So the death of the patient is not a sufficient ground for the doctor to go about town saying, hey, that man, he died of HIV. No. Then, right to obtain medical records contained under Section 23. We have rights to decline or refuse treatment still under Section 23. Now, in Cedar Way, against Board of Governors of Bethlehem Royal Hospital, the court held the patient is free to decide whether or not to submit to treatment recommended by the doctor. If the doctor, making a balanced judgment, advises the patient to submit to the operation, the patient is entitled to reject the advice for reasons which are rational or irrational or for no reason. So the patient can say, I am not taking the treatment. And the doctor says, why? He says, I don't know. You recall the case of a medical and dental practitioners disciplinary tribunal against Okonkwo. Then right to terminate service or medical service, right to terminate a health service against medical advice. The patient has a right to say, I'm not doing again. I don't want to continue to receive treatment from this facility. Then you have a right to transparent billing Section 11B. I think it was Sunday I was citing that case. Was it in your class? Mr. Jonathan Tenagon against Benue State University Teaching Hospital. In that case, a man took his son to the hospital, and when the hospital wrote out some prescription, they also wrote some consumables, but the hospital didn't have one. So the man went outside and bought one for his son's treatment at 2,500. But when the hospital was computing the bill, if you remember our lecture under medical fraud, when the hospital was computing the bill, they now included the 2,500 naira bill, which they did not render that service. And in the course of trying to get the man to pay the bill, they detained the man's son for more than 10 hours. The man went to court. The court of first instance agreed with the hospital, but the man went on appeal, and the court of appeal reversed that decision and fined the man the sum of 250,000. So the hospital was to pay the man 250, or rather the court slammed damages of 250 in favor of the patient and ordered the man to return the initial 2,500. We have right to clean, safe, and secure healthcare environment, have right to religious observance, and you have right to lay complaint, Section 30 of the National Health Act, right to lay complaint, the National Health, the Patient's Bill of Rights, right to clean, safe, and secured healthcare environments, the right to religious observance, standard minimum guideline for human rights of COVID-19 patients in treatment centers in Nigeria. Then, right to freedom of movement and freedom from detention, Section 41 of the National Health Act, Rule 20 of the Code of Medical Ethics. Then the case of Ngozi Osegbo and one order against the registered trustees of Synod of the Diocese of the Niger. The court awarded 500,000 in favor of a woman who was detained along with her husband because of hospital bill. They had lost their baby and asked the hospital to be given little time to put themselves together. But the hospital was more interested in the medical bill, in collecting their bill, and they detained the family, the man and his wife, along with the corpse of 11 years old baby. The family sued, and they got judgment, and the court awarded 500,000 in their favor. A patient also has a right to continuity of care. We said you have a right to discontinue your care. Now, after you have discontinued and you come back and say, now I want to continue, the hospital or the doctor should still receive you and continue treating you without any prejudice, or to say, yes, you said you are not doing again, which we are not doing again. So that's it. The patient, what are the conducts that amount to violation of these rights? One is where hospitals turn patients away. You should know that there's a difference between dismissal and referral. Referral is a valid medical service where the hospital writes a letter referring you to another facility. It's a valid medical service. But where the hospital dismisses the patient, it's a violation of the right. Consent, conducting surgeries without consent, or in disregard for the religious belief of the patient. We look at Okonkwo's case again. Then sharing of patient information without the patient's consent, or poor handling of medical records that information could leak, is also a violation. Patients being treated disrespectfully or harassment, different standard of care for poor, is a violation of their rights. Then being charged for items or services not disclosed, or items bills or itemized bills withheld, violation. Then facility taking long or denying patients access, it is also a violation of the patient's rights. Now, there are three delays that leads to death: delay at home, delay within the hospital premises, or delay on the road and delay within the hospital premises. Now, there are circumstances that could cause delay at home. There are also circumstances that could cause delay on the road. Now, these sometimes are not within the control of the patient or a third party, but delay in the hospital is within the control of the hospital staff. Once the patient has passed the hospital gates and the hospital still delays in attending to the patient, they might be held liable if sufficient proof is tendered before the court to show that that delay was deliberate. Then we have clinical trials without experimenting, without consent. Then we have poor sanitation in wards. Please, when you go to hospital, stop putting your hands everywhere. Maybe you're walking, you see hospital rail, then you put your hand and glide down the rail. You just come to wall, you kneel, you lean rather, and all that. Stop it as much as you can, because there's what we call hospital-acquired infection, where one can walk in with a different ailment and comes out with a different infection altogether because the environment is not safe. Now, the environment is not clean. There have also been cases where patients have been robbed, dispossessed of their belongings, and the doctors or healthcare professionals too. That's because the hospital was not secured. So you just have to be careful when you visit hospital. Then we look at the impact, consequences of violation of patients' rights, harm or loss to the patient, loss of life, psychological trauma is there, loss of trust in healthcare system, legal liability for hospital, that's medical negligence litigation, then public health implications, people avoid seeking care, and the outbreak may worsen. Dennis, please control that person. Then we have a socioeconomic cost too, where the person keeps spending. Then we look at available redress. We look at administrative redress, where the patient complains to the hospital management for them to take action. Sometimes it works. It ordinarily, if the hospital management had professionals engaged as in-house counsel, if the hospital management had medical lawyers at their services, most cases should end or would have ended at administrative redress. But the challenge is the hospitals tell the patient off and tell the patient to do his or her worst. You now see where hospitals get sued by the patients. Institutional redress, institutions like the Human Rights Commission, National Human Rights Commission, and Public Complaints Commission should also be empowered to hear patients' rights violation cases and award, I wouldn't call it damages, but compensations, promoting alternative dispute resolution. Then we have professional redress, where the victim complains to the professional body, the disciplinary arm of the professional body of the doctor or the nurse, and that doctor or nurse is tried by his or her professional colleagues, and a pronouncement is made or handed down. For the medical doctors, there are only three pronouncements that could be made. One, the doctor could be cautioned, the doctor's name could be struck off the register, or the doctor's license could be revoked or withdrawn, and the person ceases to practice medicine. But that usually happens in extreme case of medical malpractice. And the presenter last Sunday also cited examples that fell under this. Then you have legal redress. For legal redress, there are two categories, either criminal or civil. Now, for criminal cases, it is an extreme case of medical malpractice, maybe issues around organ harvesting. Maybe the doctor was grossly negligent, leading to loss of life. For example, there was a case in Lagos where a patient was sick in a particular facility and was on oxygen. Later, facility A now referred the patient to facility B, and while referring the patient, they removed their oxygen. Of course, the patient died before getting to the other facility. So that was gross negligence. Unfortunately, that hospital was not sued. The family of the patient just took it up, did some things on Facebook, and that matter, to the best of my knowledge, did not really go to courts. So that is it. But for civil action, where case the negligence of the healthcare professional leads to loss of earning, you can recover damages for psychological torture or trauma that were put through, for loss of earnings, then for continuous treatment. Maybe the patient is now paralyzed and will continue to take medication for the rest of his life. How does he get this medication? You include it in your claim for damages. Then, what are the challenges in seeking redress? We look at lack of awareness among patients, ignorance of where and how to seek redress. Illiteracy is one of them. Weak enforcement mechanisms / regulatory oversight. We also have cultural barriers, particularly where we have patriarchal decision making, where the eldest male in the family's opinion or decision holds sway, and in most cases serves as the final decision. Then respect for the dead as one of the cultural barriers. Respect for traditional institution is one of the cultural barriers. Where someone dies and you say let them conduct autopsy, and the parents or the family will say no, let the spirit of the dead rest. Don't trouble the spirit of the dead. Then sometimes where a case has been filed before the professional disciplinary body and the traditional ruler, or even in courts, the traditional ruler of the plaintiff calls the plaintiff or claimant and says, okay, just withdraw, leave vengeance for God, and the person withdraws the case. Improper evidence gathering, evidence tampering, then religious barrier, then emotional traumatization. These are a few challenges in seeking redress. Some of them, they might say they don't want to, they are seeking closure, so they don't want to go through the pain and trauma all over again. Then you have lapse of time, limitation of action. You have poverty, cost of seeking redress. You have stigma and discrimination. You have inadequate data documentation and record keeping. Because you need data, you need record, you need documentation to prove your case. Where there is no case notes of the patients, what do you do? To even show, even though it's against the doctor. Then inexperience on the part of lawyers in representing in presenting the case of the victim. Then legal and bureaucratic obstacles, delay in court hearing cases of the victim. These things discourage the victim. Then we look at barriers, it still continues. Denial of access to records, we will soon deal with evidence gathering, threat to life in some cases, confusion because the patient doesn't know what he or she really wants. Then abandonment of the case by the patients. I have suffered these last two, I've experienced them. Then what are the legal remedies? You can go for damages. You can go for restitution. Now, restitution is provided under Section 15 of the Compulsory Treatment and Care for Victims of Gunshots Act. Even though no specific amount was mentioned, but that act saying that the court can make an order to restitute for the loss of life. And my question is, how much can you pay to restitute for the loss of life? Then for claims for damages, you have pecuniary, you have non-pecuniary. You can, for damage for pecuniary economic loss, you plead the expenses that have been made. You plead medical bills, you plead continuous treatment that will still continue, you plead loss of income. Then for non-pecuniary, the pain, suffering, emotional distress, loss of amenity and all that, you plead them. Then you can also, the newest trend is enforcement of patients' rights through through actions under fundamental human rights. That's chapter 4 of the Constitution. You can also come through fundamental rights enforcement. So how do we improve and safeguard patients' rights in Nigeria? Here are recommendations. Sensitization and awareness campaign on patients' rights. We enact Patients' Rights Act and enforcement procedure. The Nigerian Law Reform Commission should also consolidate our patients' rights laws. Then relevant agencies to strengthen patients' rights. Then ensure accessible legal aid for indigent victims of patients' rights violation. We look at developing clear protocols and SOPs for obtaining consent, for record keeping, for transparency in billing. Then we have to promote alternative dispute resolution because sometimes litigation takes donkey years for the victim to perceive justice or experience justice. Then some cases will drag for donkey years, and that may cause the victim to lose interest. But if it is ADR, particularly arbitration or even mediation, within 3 months, within 6 months maximum, parties are done. Then there is need to empower institutions like the National Human Rights Commission and the Public Complaints Commission to begin to bring relief. Sorry, excuse me, I have a guest. Just 2 minutes, I'll be back. Are you done?
So thank you very much, sir. And you give me his feedback on chapter 1.
Okay.
If I can proceed to chapter 2.
Okay. So, but this material.
Yes, I did.
Okay, so keep them there. When next are you coming?
I would need to get to chapter 3 first. So
okay, so what you got today can carry you to chapter 2.
Yeah.
Awesome.
I'm finished chapter 2. So probably by God's grace, December. But the last time I should be in chapter 3.
Okay.
We're not rushing this.
Okay.
He takes his time. So.
Okay. All the best.
So thank you very much, sir.
You're welcome. You're welcome.
If I'm to come back anytime now,
just let me know. It's
thank
okay.
You very much.
You're resuming school when?
5th October.
5th. So what will you be doing at home between now and
then? We have other personal work that I do.
Okay.
Myself.
Okay.
Thank you very much.
You're welcome. All the best. Sorry, class. It's one of your people. Sorry, he's a student too, an undergraduate with a university. He's writing his project in medical law. So someone referred him to me. He came to make use of some materials in the office. So we are talking about empowering the National Human Rights Commission and other institutions to begin to provide relief, begin to provide compensation for speedy compensation for victims of patients' rights. Now, that's going to rhyme or tally with the last point. Introduce no-fault compensation scheme. Now, no-fault compensation scheme is already being practiced in other jurisdictions, where if the claims are small and the facts are clear, a case of Rep Sister Lopito, the victim doesn't need to prove because the facts are there. So that's why we call it no fault compensation. Yes, the victim doesn't need to go through proving all that has happened before he gets compensated. So those are the recommendations on how we can preserve and promote patients' rights in Nigeria. So any question before we go into our second topic quickly? Any questions on this? Hello, can you hear me?
Yes, sir.
Okay, any questions? Yes, Priscilla, your hand is up.
Okay, good evening, sir.
Good
So I want to ask
evening.
2 questions.
Okay, could you be more
First,
audible?
I said I want to ask 2 questions.
Yes.
So the
Ask.
first one, when you were talking about the rights, you mentioned rights to continuity of care.
Yes.
Discontinued care before. So the
Yes.
question I would like to ask is that what if after discontinuing the care, the person's condition has gotten so much worse that even if the hospital should decide to continue the care, the probability that you would live is close to 0. So can they just say, okay, we don't want to take you again because after you discontinued the care, your condition has worsened. So
Deteriorated.
yes. So that's the first question. The second question is about the case that you mentioned, the Okekere versus Tanko case.
Yes.
So is it the general rule? Because the general rule is that a minor cannot
give
a minor
consent.
cannot
Yes. Now
exactly
that's the general rule of consent, but there is what we call Gillick competence, and that's why you are in this class. To every general rule, there's an exception. Have you heard something like that before?
yes, sir.
Beautiful. Now, the rule of Gillick competence says that where the minor is able to understand what is going to be done to him or her body. Gillick competence rule was developed in a case of Gillick where a lady who was under 18 was to seek care regarding her reproductive health. Now, reproductive health is something sensitive, and the person wants to decide whether to use contraceptive or not, and wouldn't want the parents to know. And it came as an exception to the general rule of consent that where the person, the minor, appreciates, understands what's going to be done, is able to, because why we are saying adults should make decisions for minors, that the minors do not understand what is going to be done and the far-reaching implications. So, but where somebody, in this case of Tanko, the boy is 14 years. A 14 years old boy can decide whether he will have his finger chopped off or not. So, Gillick competence becomes an exception to the general rule of consent that minors cannot give consent. Of course, the minor has to be of sound mind too. Then for your question 1, remind me the question again, please.
I said that if after discontinuing care.
Yes, after discontinuing care. Now, there are different types of care. There is preventive care and there is palliative care. Do you understand? There are certain class of ailments they call terminal. They tell you that it is not curable, but manageable. So the hospital begin to manage the patient, but they will not cure the ailments because they do not have the cure yet. So where a patient has withdrawn care, in 2018, I did a 2018, yeah. I did a case. A woman was undergoing dialysis. Later, she withdrew from that hospital and said she's not doing with them again. She went to another hospital. The second hospital said that their generating set is bad. So their dialysis machine was not working due to power outage. So she stayed for some time at home before. In fact, while she was at home, the son engaged me that we should sue the hospital. So I told the son we will still be processing our papers to sue. Your mother will die. So why don't we engage with the hospital? And I secured an appointment with the CMD and we went. The hospital took her back and continued the treatment at no cost even. So, but the caveat here is where the patient is a threat to the hospital or a threat to the doctor, because doctors are also human beings and they also have this right to life we are talking about. Doctors also have right to life. Where the patient is abusive, whether verbally or physical, to the doctor, or even the patient's relatives are abusive to the doctor has a right to decline treating them, and the court will uphold it. Because when we are telling the patient, when you are telling us the patient has a right to dignified care, the doctor also has a right to be respected by the patient. So if a hospital refuses, except where this exception applies, the hospital could be liable if sued. So any other question on this? Any other question on this before we move to our next topic? Okay, I'll give 2 more seconds. In the absence of any other question, we go to our next topic, which is evidence gathering. Very interesting topic. Okay, what is evidence? Let us start from there. Evidence gathering in healthcare litigation. What is evidence? Now, evidence, of course, we know what it is. Proof. Documents that show anything that supports your claim to convince the court. Now, the group 2 did a beautiful job by listing the types, what we can put together and call evidence in medical litigation. The hospital records, starting with the card, the hospital card. What the hospital card establishes is doctor-patient relationship. You know, we said for you to succeed, you need to, sorry, please, my battery is about to go down. Let me plug this. Just a moment. Okay, good. So the first and most important evidence you need is to establish duty of care. And how do you establish duty of care? By establishing a relationship between you and the doctor. So you need to prove that you actually were a patient or that your relative was a patient in that hospital. And how do you prove that? Your card, the hospital card, you plead it. You not only plead it, you attach it. Because when you tell your story, some people don't know how to tell their stories. And your pleadings is very important. What we call pleadings generally is your story. What led to what happened? So you don't start by telling the court what you suffered. How did you find yourself in the hospital? That's part of your story. Now, when you're telling your story, you need to mention names. What's the name of the doctor that treated you? What's the name of the nurse that treated you? What time of the day? What shift? Was it morning shift? Was it night shift? That is one. Two, your own people too who were there. Now, if you want to talk about your witnesses, because one is your medical record, now the document doesn't speak. When you have put in your documents, somebody needs to speak to those documents. Somebody needs to give life. If you say, I was admitted at so and so hospital, this is my card number. Somebody needs to corroborate that your evidence by saying, yes, this person was in this hospital. So this now brings me to your witnesses, who you are calling as witnesses. What is their capacity? Particularly your expert witness. If a doctor, let's say a cardiologist, you have a case against a cardiologist, you do not go and call a nephrologist. A cardiologist deals with the heart, a nephrologist deals with the kidney. Both of them are doctors working in teaching hospital. This one is working in teaching hospital A, this one is working in teaching hospital B. So if the doctor you are suing is a cardiologist, the best you can do is to get another cardiologist to give evidence in your favor. Because if you bring a nephrologist, he's not an expert in cardiac issues. So his evidence will weigh less on the scale of the court. Secondly, if the person you are suing is a consultant, you do not go and bring a resident to serve as your witness. A resident is a doctor that just passed out of medical school and is undergoing residency. Those people you see wearing white lab coats in the hospital. So his knowledge of his practical knowledge or expertise is still very, 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 very low compared to a consultant. A consultant must have practiced medicine for at least 10 years. At least 10 years. and the resident is still doing his residency. In fact, it is after that residency and he is issued a certificate of experience, that is when he will now go and complete his registration with the Medical and Dental Council. That's when he becomes fully registered. As at the time he's doing residency, he's under probational registration. So you now see that he is not qualified to come and give evidence against a consultant in a particular field of medicine. But people don't know these technicalities. They say, okay, he is a doctor, I'm a doctor, or he's a doctor, my brother is a doctor, my brother can also testify. That is why this place, this medical law field is technical. And if you don't know the technicality, you will miss out. Even when you have a beautiful case, you will lose out on your case. Then another issue, very important, is now how do you gather this evidence? One way, even though you are not going to hospital to make trouble, one, you are not going to hospital with the expectation that things will go wrong. But there is need for you to do journaling. Journaling is one way to gather evidence. Two is, before you sue, don't even threaten the hospital. If you feel anything is wrong, don't threaten, don't ever say, when we get out of this place, we are going to sue you. No, calm down. Get all the evidence you need, including your medical record. So how do you get your medical record from the hospital? Very easy. When they have discharged you, remain friendly with all of them. Then apply for your medical record that you want to seek a second opinion elsewhere. That's the only way they can give you your medical record intact. But where you have made trouble with them and threatened them that you are going to sue, they will keep turning you down, up and down, and while they are delaying you, come today, come tomorrow, the doctor that will sign is not around. While they are doing that, they are doctoring your record. By the time they hand the record to you, what is inside is not what transpired. The medical record will speak in their favor. So, evidence gathering, it is not in all cases that you quickly rush to court. And like I said, medical negligence case should only end up in court where that is the last resort, or patient's right, of course, where there is criminal elements, do not hesitate to take the matter to court. So you take your time and gather your evidence and weigh your evidence. Now, your evidence should also contain, because you want to establish error. So when you have collected these documents, you also are supposed to go and run a test. You are also supposed to go and seek a second opinion that will now discredit the one you are challenging. Because where there is no second opinion, are you a medic? 2 questions in the witness box and you are gone. You will agree with me that you are not a medical personnel. Yes, my lord. You will also agree with me that not being a medical personnel, you do not have an authentic opinion. You do not have authentic opinion, or you do not have expert opinion. You do not have the expertise to interpret and comment on these documents before you, this medical report, this result you are holding. you do not have the expertise to comment on it or interpret it. Yes, my lord. And that will be all. Because you are not a medical doctor, everything you say about that document makes no sense to the court. You do not have the expertise to comment on that document. But where you have gone to run another test, where you have gone to another hospital and now have another set of documents that contradicts what you got from hospital A, you can now use this other document to tell the court that this is what this hospital did, which was wrong. I went to this other hospital. This is what this hospital found out, which is correct. Yet you are still not the person to present that document. So you need an expert to bring in that document. So evidence gathering in medical negligence litigation is a technical issue. There are some that I will not tell you in this class. Those ones are for advanced class. Now, I saw one case here. Ojo against Garoro's case. It's a very interesting case. Now, this is where liability is pushed to manufacturers. The woman underwent a surgery and a surgical needle was left in her abdomen. Who? Okay, let him just wait. Are you leaving? Okay, Abigail, come. She's around. Okay, I will just random. Let him wait. Tell him I am in the weapon. I'm in the class. Okay. So in that case, a surgical needle was left in the woman's abdomen. Of course, it is a case of Res Ipsa Loquitur. But what they narrowly escaped liability because the X-ray notes were not sufficient. But the bottom line of that case is that liability of burden was actually shifted. The people are saying these manufacturers, it is really not our fault. The manufacturing company did something substandard. But I personally do not agree with the finding of court in this case. I personally do not agree with the finding of court in this case. If I was the judge, there is a needle, whether it is fake or original, are you supposed to leave anything there? What happened there is negligence, because the standard procedure for operation is before you go in, before you open up, you have a list of all your items. You count them. You note how many there are. We have 24 instruments we are using, surgical equipment we are using here. Then you start your operation. When you finish operating, before you close up, you count them. Oh, they are now 22. Where are the other 2? You start looking for it. If you don't see that, you don't close up. But in this case, a surgical needle was left. Whether it was fake, whether the record was right or wrong, the human beings, part of your anatomy does not include a surgical pin, surgical needle. So I personally disagree with the finding of the courts in that particular case. So I needed to bring that out. Of course, we've talked about Okonkwo's case. That's what you repeated here. Then, finally, and very, very finally, because some people are waiting for me. Evidence gathering is not a day's job. As a lawyer, as a healthcare, medical negligence practitioner, you need extreme emotional intelligence skill to engage with them. Sometimes it is the nurses, even when the management is trying to subvert your case, sometimes it is the nurses that are sympathetic to your cause that will give you the correct evidence. So the point I'm making is this, that evidence gathering is not a day's job. It is what you need patience. 1, 2, medical negligence litigation has 3 years as the limitation of action period. So something that happens today doesn't mean that you should rush to court tomorrow. Take your time. Now, in taking your time, it does not mean you take 3 years. What it means is you should gather your evidence first, because the court is not Father Christmas. The court deals with hardcore evidence. No matter how beautiful your case is, if you cannot prove it, the court will throw it away. And that is what happens in most cases that people complain. Then they now accuse the court of bias. They now accuse the court of compromise. They accuse the court of bribe. No, it is not in all cases. There's a particular case, a respected senior advocate I hold in very high esteem did that matter. As I speak, that matter is before the Supreme Court. But there was a slight mistake on his part. If you are doing medical negligence, you must establish duty of care, breach of duty, and harm as a result of breach of duty. After that, you now establish nexus, connection, causation, that this harm was caused because this person breached his duty of care. He established duty of care, he established breach, he established harm. He even had the documents to establish causation. But for whatever reason, that document was not pleaded. And based on that singular act, the court denied judgment. So we are going to stop here so that I can attend to some other students waiting for me. But before we do, any questions on evidence gathering? Any questions? Any questions? Any questions on evidence gathering? Okay, so I assume there are no questions. Any questions for me? If you don't have, I can ask you.
For the mentees, please let's ask questions. If you have any question you would like to ask, please do well and indicate.
So if you don't have, I will take your silence to mean that you understood everything I said. Have you taken your picture for today, or you took on Sunday?
No, sir, I didn't. I will do that right now after you are done speaking.
Okay, kindly do, because some other students are waiting for me downstairs.
All right, so please, for the mentees, let's quickly turn on our videos for our pictures. All right, thank you, Benis. Thank you, Diola.
Some mentees are yet to introduce themselves. We have had 3 persons so far. I think Priscilla has introduced herself. Blossom has introduced herself. I can't remember the 3rd person who has introduced herself. So the rest, we will take that on Sunday. By the time we start the class, the first 10 minutes or 5 minutes, we take another set of introductions. Then we continue because we have barely 3 more classes to go or 4 more classes to go highest. So I need to know all the names of my students. Okay, so you can take your pictures now.
All right, I'm done, sir.
Okay. Thank you very much. See you all in class on Sunday.
Thank you,
Thank you very
sir.
much. Thank you very much, sir. Really
It's
do
okay.
appreciate
All
it.
the best.
Before
Bye. Pray that I have work to do. I'll just come to the office and do the lecture. You can see we did not have any interruption today. So maybe my location is also contributing, but I doubt. We've been having lectures there now. Okay, let's see how it turns out. Goodbye, everyone. Enjoy your evening. You are submitting your work tomorrow, right? Or Thursday?
On Thursday, sir.
Thursday,
Yes.
sir.
Okay, awesome. Awesome. Goodbye, everyone. Enjoy your week.
All right, goodbye, sir. All right, so for us, before we go, sorry, just a minute before we go. All right, please, if you're having any issue with the work or the timing of the work, please reach out to me. Right, I want to see if there is going to be a way for me to extend the time if people will not be able to meet up. Based off of the fact that it was kind of impromptu and you had not done the class yet. So I assume that there may be some delays, right? So please, if people are having any particular issue with your work, right, please do well to reach out to me. Let's see how we can work on getting it ready by latest Friday. If Thursday it won't be possible. All right, please do all take good care of yourselves and bye bye.